say we will brave disqualification, but this chief minister has to go. But look at, my lord, the Representation of People Act. You may have a person who's elected on which there are allegations of booth capturing, of violence. I remember, my lord, once somebody was arguing the case for one of the persons from Bihar, my lord, who was in jail, and saying he should be allowed to come. Mr. Tulsi was arguing, and he told Justice Nanavati, he said, see the majority by which my client has won the election. And Justice Nanavati said, if your client had his way, he would have had no opponent. He would have killed all of them. So, my lord, those kind of cases are pending. A person, my lord, a known mafia king, against whom there was a murder trial pending for publicly gunning down people, continued in office.
Where does it?
In the High Court and sometimes in appeal in this court. You have cases of the worst kind of electoral offenses pending for trial. What happens to those people? They continue in office. So, my lord, there is nothing so shocking that in our system, many times people continue in office where there are serious allegations pending against them. That's the bane of our system.
Thank you.
Thank you. Thank you.
Now, with that, my lord, see the language of 191(2). A person shall be disqualified for being a member if he is so disqualified under the 10th schedule. So that disqualification must take place. And that disqualification in the 10th schedule does not take place until there is a decision of the chairman or the speaker under paragraph 6. Any other view, my lord, would be equally or would be far more disastrous, because today all you have to do then paralyze the working of an assembly is to file disqualification petitions.
Mr. Salve,
Yes.
till here there is no problem.
Yes.
The position under the Constitution is very clear.
Yes.
And also the judgments of this court.
Correct.
Concluded with this expression, the decision.
Yes.
The problem arises the time, context, and the stage at which speakers choose to take a decision.
Yep. I was going to straight away address, but yeah.
I mean, in that,
yes,
it is in that context that
yes.
Either that he shows over anxiety to immediately decide violating principles of natural justice, or he just doesn't decide for times to come.
So the short answer
of pending 10th schedule proceedings.
Yes.
The powers to be exercised either by the governor or the political process, as it were, goes on.
Yes.
So makes the application redundant many a times.
May I not respectfully answer? This has been the biggest problem of appointing a speaker. Mr. Sibal was right when he said, your lordships express hope and faith that the institution of the speaker will rise above politics when it comes to the 10th schedule. Our experience may not have fully risen up to those expectations. But that's where we have to drop that. The point, my lord, is this. Respectfully answering Justice Narasimha's question. If your lordship has seen, the rules here have in one sense a constitutional status, because the rules are framed as a delegate under paragraph 8. And those rules can and should provide a time frame in which these petitions have to be decided, both giving fair opportunity. So these rules normally say you will give so much time for giving a reply. One of the reasons why our group came to court is even that time was not given. And equally, perhaps its time has come for the rules to say, if a petition is filed, he shall, unless there are compelling reasons to the contrary, dispose it off in 90 days or 60 days or something like that. And there, my lord, then judicial review will come in. If a speaker is dragging his feet and the rules say he must decide it absent compelling reasons within a given frame of time, judicial review will come in. You can go to a high court and say, issue a writ of mandamus directing him to dispose of, because then you will have a legal right to ask for a decision within a given time. So, my lord, these are the only ways in which your lordships can address this lacuna. Now, what is the relating back? Relating back has two dimensions. The event has taken place. So ultimately, subsequent events will not affect, it will not efface the wrong which you have committed, the political wrong which you have committed, which disqualifies you. It's over. My lord, if you enter into an office of profit, you're disqualified. If you resign 3 months later from that office of profit, it is not saved. You're disqualified on that date. So, my lord, that disqualification is based on a set of events. But please consider the consequences, which will be contrary to the terms of the Constitution, which says no act of the House shall be declared invalid merely because a member participated who was not entitled to. Now, first of all, here you are entitled to participate, but even if a wrong person comes in, you cannot go annulling the work being done. Today, my lord, when the defection petitions are decided, if some of them are allowed, in between laws have been made, resolutions have been passed by the House, all of them can't be revisited. So, my lord, that's the respectful answer to the ex post facto point. That as a matter of law, and my lord, I read, since your lordships have kept this question back.
What were you saying, Mr. Sari, as a matter of law?
As a matter of law, my lord, I read the Nabam Rabia judgment not as laying down an absence of power, but as laying down a code of conduct. Let me explain what I mean, my lord. The speaker is...
On the ex post, Mr. Salve, in a sentence, can you just summarize your ex post facto on ex post facto? What is your, so we'll just, if you formulate it, we can take it down then, you know.
My formulation of ex post facto is as follows, Madam. The disqualification will have to be decided on the basis of the acts and omissions of the allegedly delinquent member on that date. But subsequent events will not cure that. If on that date you defied a party whip which was lawfully issued, that's the end of the matter. The fact that the party collapsed thereafter is neither here nor there. If it is pursued to its logical end, that wrong has been committed. And I give, my lord, the example of somebody who takes an office of profit. Let's get into non-controversial.
If you can just continue to sort of complete the formulation, I got that the disqualification will have to be decided on the basis of the acts and of omissions of the allegedly delinquent member on that date.
When he committed those acts.
Will not cure that.
Will not efface.
The call also said.
Will not efface.
So what is the sequitur?
Yes.
What is the sequitur?
The sequitur
how do you formulate
is, however, until the date of decision. If this is so, my lord, we have no problem in reconciling to the fact that people with the most serious allegations of having been elected by wrongful means such as booth capturing, threatening witnesses, or rampant corruption in election also continue in office. That's one of the banes of our system till such time as a election tribunal declares them to be wrongly disqualified. That's the way it is. So, my lord, my respectful submission is that yes, the rule should be amended. Decision making should be made time bound. Judicial review will be available where a speaker is holding back. All those are ways which we can fix this. But, my lord, the legal consequence of the pendency of these proceedings and its ultimate decision, this is the principle of ex post facto which must apply. No less, but no more.
Anything else, Mr. Salve? We got the
Yes.
ex post facto.
Third point which I wanted to make, my lord, is since the point is still in play, the Nabam Rebia judgment, and I had, my lord, given a note earlier. I believe Mr. Trivedi had handed it over. Mr. Jetmalani had handed it over.
Last time you read also when you appeared.
Yes, my lord. No, after that I gave a note, my lord.
That was there.
I read the judgment as more not the absence of power, but the manner of its exercise. So it is by filing a disqualification or rather a removal of speaker, because all those provisions are shown to your lordship saying the speaker doesn't, as a matter of law, is not put in suspension. They are right. So there is no absence of power. I was not only saying
It's about the manner of exercise rather than the absence of power.
correct, because my lord, abuse of constitutional power is a head which we now recognize for judicial review. Is my lord the Chief Justice saying something to me, my lord? I can't hear.
You don't read Nabam Rebia as an absolute principle that the speaker is disabled from exercising his jurisdiction when there's a motion for his removal pending.
No.
It's a caution to the speaker, and ultimately it's for the speaker to take a call whether there's a frontal assault on his continuance, whether he would like to go ahead with the hearing of the disqualification petition.
And as I read that judgment, my lord, your lordships have not said that the speaker ceases to have power, but the
So what you're
manner
telling
of
us would be either to sort of restrict it a little bit or put a gloss on the judgment. I mean, if you really read those,
my lord, we always judgments are not statutes, and we always learn to understand them. Sometimes when things are written, my lord, those facts were very stark, so maybe the language used was a little strong. But I read that judgment as, because please see, my lord, the analysis, and your lordship has read the judgment. I'm not going to waste your time reading it. The facts were so stark. What really your lordship was doing is that saying is that the speaker had no business to do this. The actions of the speaker in that case, my lord, were open and shut case of abuse of power, is the finding. So I don't, my lord, read that judgment as absence of power. Your lordship never said that he ceases to have. There are 50 other things the speaker does, my lord. He runs the whole administrative office of the legislature. Surely he's doing all that. It's only in one area that the speaker should not act. If there is, my lord, pending consideration of all these rumpus, if there was any other resolution, of course he would preside and run the house. So, my lord, once your lordships read that judgment that way, that what really the court was trying to say is not an absence of power, but the actions of a speaker will be tested. A speaker should be put to caution when there is a notice for his removal. His actions will be tested on well-known principles of abuse of power. Then, my lord, the concern which your lordship have would go away, with that judgment being read as absence of power. And finally, my lord, if I may just hark back a little to my first opening point, apart from this understanding of the Nabam Rabia judgment, my lord. Nothing else really survives. There is a note which I believe is placed at note J. My lord, I believe, I'm sorry, my friend informs me, my earlier note saying what I have just formulated for your lordship's consideration is in note F. And there is yet another note, note J.
Last night.
Yes, this is only to show the hazards of the but-for test.
Note J.
I was just told, my lord, it is marked as note J.
It's written submissions. It doesn't say note J.
It says brief note on arithmetic for hypothetical trustworthy.
What's that?
Mathematics.
Yes, it's just the math. Only, but this is only to indicate to your lordships that this but-for test is extremely hazardous. To guess what would have happened on that fateful day had a trust vote taken place is inviting
not-
rank speculation.
I got Harish Salve's name.
F is the earlier one on the Constitution Bench judgment, the Nabam Rabia judgment.
दोपहर को कर दे दोपहर को हाँ कर दे
हाँ.
हाँ प्लीज
And this note J, my lord, only sets out, I'll quickly tell your lordship what we have basically said.
Notes तो तेरा
नहीं है वो अलग है
I have given, my lord, different places where in the writ petitions they have mentioned.
You sent it on my mail, personal mail, na?
Basically, my lord, this gives you at one place. Please, it's not there. It's no big deal. Your lordship knows it is there. Basically, what we are trying to say is, we have given your lordship the para numbers and the page numbers.
तो डाउनलोड कर देना बाद में उसको
Thank you.
If your lordship sees the from paragraph 3,
नहीं.
Email ID thing.
on 23rd June, only 16 disqualification petitions were filed. Let's be very clear, my lord, of a few dates. On 25th June, Speaker issues notice to 16. The order of your lordships on 27th June was limited to 16. The suggestion. There was 39 or 40 disqualifications. In fact, my lord, look at 4C. There are two of them who are independents. They may vote one way or the other. Their party to decide whether they consider it a breach. No prayer in any of the petitions that 39 or 40 should not be allowed to vote. So, my lord, these figures which are being given, and I've given your lordship the shifting stands in different places. And I, my lord, again underscore the point. This was only
Mr. Sibal, Mr.
To
Paul,
finish,
Mr.
Malak,
all of you,
this-
what you were thinking was that Mr. Salve, roughly,
I'm done in 5 minutes.
That's all right. But it won't finish now. Can't finish. There's no point.
Mr. Salve, you will take about
5-7 minutes.
5
I'll be done by
Okay,
lunch.
5-7
Yes,
minutes.
100%.
Mr. Jethlani, we are not at all rushing any one of you because these are important matters of moment. We are not just forget the facts, but we are thinking of a matter of a moment. So, how much would you take in terms
Ordinary circumstances, about half an hour, but I could curtail it to 20 minutes, 25 minutes.
half an hour? Then, Mr. Maninder Singh, half an hour, all right. Mr. Solicitor,
Are few more minutes, bro.
so you will between the three of you will take 2 hours.
Realistically speaking, it may not be over.
All right, Mr. Call, one more thing. I thought we curbed you unduly, and then you were gracious enough to follow our edict. But the idea was to finish today, but we may not be able to wrap up today.
Yes, yes,
It doesn't
no
appear that we'll be able to wrap it up today. In which case,
Then
Mr.
let's
Call,
have it on Tuesday then, Malad.
Mr. Call, one more thing. Is your conscience clear that you are satisfied that you've argued fully? Is there something which you would have still liked to, because as a judge who's seen so many seasons,
Never give
I
that
don't want you to
opportunity
leave.
to a lawyer, Malad.
You don't want to give the impression that you're not.
I would have liked to take your lordship through some of the judgments if I could, which I rectified. But what do I say, my lords, to this? I can't. I leave it to your lordships. I can't say.
All right. What we will do is this: we will hear Mr. Salve now and just wrap it up, or we can. क्या करें?
Malad, let's wrap it up and then have it on Tuesday, Malad, on the after reopening. That's the only way, Malad.
On the reopening. Reopening.
Something you want to still show us in the morning after Mr. Salve has wrapped up. We'll give you a little time. So that, you don't feel that. And anyway, there's no prejudice to Mr. Sibal because you still have to rejoin. So
Yes, yes. Now, Malad, I'll sort of rejoin without the haste.
would it be all right to assess that on Tuesday in the first session, the three of you will be able to finish?
Yes. Yes.
Right? Maybe so. If you take.
But are we not continuing this afternoon also?
I think
No,
there's
no
point
need,
because they're
Malad.
now going spilling over beyond the.
Oh, yes.
Where there's no
Then
point
we'd get some more time also if it was full.
isn't it? Then what we can do is we can keep it on Tuesday. Mrs.
Yes.
Salve, we'll hear you for 5 minutes on Tuesday.
Yes, yes.
You may want to just.
Very well.
And then, Mr. Paul, if you still want to make a few submissions in your judgment, no problem. We'll hear you on that because let's not go.
Yeah, very kind of your lordships. Very kind.
Then Mr. Jethlani and Mr. Maninder Singh, and then we'll hear the governor, Mr.
After Malad,
Tushar.
I'll.
And equally, Mr. Sibal, we'll give you a full.
That's right, Malad, because there's lots of things that have been said, Malad, which.
Mr. Sarode, what is that you wanted to say now? And don't mention anything. Huh? We're not. This is not mentioning time.
No, Milord. Milord, I am intervener on behalf of the voters. I may be given some time to, Milord, narrate the.
Mr. Sarode, if you allow interveners and then
Whenever possible, Milord.
There'll be interveners on this side, interveners on that side.
no
Give us a
problem.
small note of a page or so. We'll look at your note. No difficulty. Just
No, Milord,
just-
I'm supporting Mr. Sibal.